I hope this finds you well. Today we look at a case that concerns religious accommodations and hiring. The case we're going to look at is the EEOC versus Abercrombie. EEOC stands for Equal Employment Opportunity Commission. The case was decided on June 1st, 2015 by a vote of 7-2, and the case was reversed and remanded. The parties to the case are the EEOC on behalf of Samantha Eloff, and I hope I'm saying that correctly, and the respondents are Abercrombie Stores. So here are the facts. Ms. Eloff applied for a position at Abercrombie. Abercrombie calls their sales representatives models, and when they are on the store floor, they have to comply with what's called their look policy. Mrs. Eloff had been into the store on a number of occasions. The manager knew of her and knew she wore a hijab. I hope I'm saying that correctly or pronouncing it correctly. The hijab was a headscarf that Miss Eloff wore for her religion. So in 2008, the manager of the store interviewed Miss Eloff for a position as a model. Miss Eloff wore the hijab to the interview, and during the interview, everything went well. Eloff scored high enough to be hired by Abercrombie or recommended for hire by Abercrombie. No mention was made to her hijab or her religious preference, and Miss Eloff did not request an accommodation to the look policy. The Abercrombie store manager was unsure on whether to hire Miss Eloff because of the headscarf she was wearing, so she contacted the district manager for Abercrombie, and the district manager told the store manager to downgrade Miss Eloff's interview score, thus making her below the standards of qualification to be hired at Abercrombie as a model. So ultimately she didn't get the job. Miss Eloff then found out that she didn't get the job because of her headscarf, and she went to the Equal Employment Opportunity Commission. The EEOC then filed suit on behalf of Miss Eloff under the Civil Rights Act of 1964. The Civil Rights Act of 1964 prohibits an employer from refusing to hire someone because of the applicant's religious practice when and if that religious practice can be accommodated without any undue hardship to the employer. So the issue before the court was whether Abercrombie could be held liable for violating the Civil Rights Act of 1964 for refusing to hire Miss Eloff based on her religious practice or observance if Abercrombie did not have direct knowledge that Miss Eloff was going to require an accommodation. Ultimately, the Supreme Court found that there's no knowledge requirement in the Civil Rights Act of 1964, and that Miss Eloff, or any applicant for that matter, need only show that their need for an accommodation was a motivating factor in whether Abercrombie or any employer's decision was made not to hire her. The court also found that under the Civil Rights Act, there's an affirmative duty created for the employer to accommodate religious practices. So basically, an employer, in this case Abercrombie, violated the act when they refused to make an accommodation or avoiding having to make an accommodation, as they did in this case with the Miss Eloff, by marking her lower in the appearance category because she was wearing the headscarf. Thanks for watching. I hope you enjoyed the video. Please like, share, and subscribe if you did. And remember, there's the full case from the Supreme Court is in the description, as well as the 10th Circuit's ruling is in the description as well.